To have Mr. Flomenhaft come to this seminar. It's a wonderful experience for this class and for Fordham Law School as well. Mr. Flomenhaft graduated from Boston University School of Law. He's really the only one expert in the country that I know of as a lawyer who has the extent of the grasp that he has on this area of neuroscience and who's practiced as much as he has in this particular area. His law firm is unique, and I spent quite a bit of time trying to look at another law firm in the country that would be equivalent to the Flomenhaft firm, and I just really couldn't find something like that. So, with no further ado, thank you.
Thank you very much. So we get started. I didn't come into the profession knowing anything about neuroscience or thinking about neuroscience. And actually, it took me a few years to find my way in the profession until finally I found my way in a personal injury firm. And the staple of most personal injury attorneys is motor vehicle accidents. In 2011, I was invited to speak to the annual Second Circuit Judicial Conference. And that's an annual conference for all the federal judges in New York, Connecticut, Vermont, appellate judges, trial judges, and magistrates, law professors. And the theme of that conference was neuroscience and law. The message that came out of that conference fundamentally to the federal judges who were really on the front line of justice was that neuroscience represents an exciting future, but it's not ready for prime time in the law. Maybe someday soon. And I was the only trial attorney at that conference with any experience whatsoever with neuroscience in the courtroom. And so the message that was conveyed really contradicted the major mission of my own career, was that neuroscience is not something in the future. That neuroscience is very, very important and relevant to justice. And it's been relevant and important to justice for a very long time. And it's almost essential exclusion from justice degrades the quality of the fact finding, degrades the quality of the justice that we as attorneys aspire to. I want to distinguish at the outset, and define at the outset neuroscience, and distinguish it from neurology. The fields overlap a little bit. But in law and justice, they get very blurred and confused. And it's very important to understand that distinction. But basically, neurology is the diagnosis and treatment of diseases of the nervous system. Whether that be diseases in the peripheral nervous system, the nerves that go in the limbs, or the central nervous system, diseases of the spinal cord and brain. Neuroscience is the science of the nervous system. And it may seem like that those two fields coincide, but they're very different. They're often and almost always posing very different questions. The question that neurology poses is what? That's its what's this disease entity I'm dealing with? What's the treatment for this disease? And the anatomy and the physiology that medicine relies upon is that anatomy and that physiology that's aimed at answering that question. But the neuroscience question is a different question. The neuroscience question is not what, but really how and why. How does the nervous system work? Why is it working this way? Medicine is very compartmentalized. You have orthopedics, you have oncology, you have neurology, you have gastroenterology. And that suffices to help a lot of people, help doctors help a lot of people by answering one question. But the body doesn't recognize that type of compartmentalization. The body doesn't conform to that compartmentalization. And neuroscience doesn't seek its answers through the prism of those compartmentalizations. And so the answer comes up with to the same questions that we pose to neurology. We're often very different than the answers that are yielded from the vantage point of neurology. As a matter of fact, they often contradict each other totally. And I think you'll find, and I hope from my remarks today a little bit, you'll see that the questions that neuroscience poses are often much more aligned with the questions that we're concerned with in the law. That we're concerned lots of times with how and why, not the what. In the law, we often look to medicine, which has the vantage point of the what, to answer the questions of how and why. So medicine is often taken into a realm really beyond its scope, beyond its proper scope, and comes up with answers that are often wrong from a neuroscience perspective. And so, if your goal as an attorney is to really find the best answer, it's often neuroscience that you have to find your way to. The problem is that medicine often comes in the normal course of a case. People are injured with their issues, they see doctors and medical records generally. Neuroscience doesn't come in the normal course of the case. If you want to find, the attorney wants to find that better answer, that often very different answer, that very contrary answer. They can't count on the physician to guide them. It's really up to the attorney, whose passion and impetus for that better answer is driving she or he to neuroscience, to formulate those questions, to find those scientists. So it's really up to the attorney to bring neuroscience to the courtroom. It's not going to happen by itself. And I'm very grateful to law. Laws have been a portal through this adventure in neuroscience and law that I've had to meet a lot of spectacular people from all different scientific, legal, and other walks of life. Talented people that you meet from all different walks of life, different from where you came. And so that's been my experience. And certainly, devotion to neuroscience and law as a devotion to any professional work yields that.